Welcome to our preview of this year's Changing Currents in Employment Law, the DC Bar's 3-hour fast-paced fall CLE that previews cutting-edge topics in employment law from both the management and employee side perspectives. I'm Scott Oswald. I am faculty chair of Changing Currents in Employment Law, and I am joined by Carter DeLorme. He is a partner at Epstein Becker Green. Carter, how are you?
Scott, I'm great. How are you?
I'm really well. Hey, you're speaking on a panel entitled Here, There, and Everywhere, the Legal Challenges of a Permanently Remote Workforce. And, we know that when the pandemic hit, companies quickly had to adapt to the work from home model. And now companies are grappling with the fact that their employees are sometimes in far-flung locations. Give us kind of a top-level overview of your topic and tell us about your co-panelist.
Thanks, Scott. It's interesting. I've spent most of my 25-year career telling management clients, sure, you can tell people that they have to come to the office and work. It's a bona fide job qualification. Well, COVID has changed all of that. And I literally yesterday was on a call with a new client trying to wrestle with the issue of what segment of their workforce needs to be there permanently because they're client-facing, client-engaging, and what segment of the workforce can be working remotely, and how do you manage those situations? I look forward to sitting down with LawrenceQueen, who is a preeminent plaintiff side lawyer, and talking from both perspectives, because this is really sort of a collaborative issue as opposed to some of the combative issues that we have on the management and employee side.
So give us like a checklist, maybe a few of the things that are kind of at the top of the checklist that you're going over with your clients right now.
Well, the number one issue when you have a remote workplace is, are we dealing with exempt employees or are we dealing with non-exempt employees? Because if we're dealing with non-exempt employees, we have to be very particular about what is work, what is not work, because good folks like you and your colleagues and Barbara as well know fully that if I ask you to jump on an email here or I ask you to follow up with something there, that's compensable time. So we have to be able to track that. So that's the top of my list.
So if let's say a company comes to you and says, this prized employee wants to move to, I don't know, Massachusetts or Maine or somewhere else, should I let them? And what does that mean for my business, right? What are you telling them?
To be honest, Scott, normally what I hear from clients is, I just found out this employee has been working from Maine. What does that mean for me? Do our DC laws apply? Do Maine laws apply? And honestly, it's a tapestry. At my firm, we're really working on trying to nail down all 50 states and in some cases, some international issues to figure out what happens when your employee says, yeah, I'm still going to work for you. Yeah, I'm still creating work product every day. I'm just not doing it from DC, Maryland, or Virginia. I'm doing it from West Virginia or, Waikiki.
Man, I am really looking forward to this panel, Carter. Thank you so much for putting it together with Barbara. We look forward to seeing all of you on Tuesday, October 25th at 6 p.m. this year in person at the DC Bar headquarters and also via Zoom remotely. You can register using the CLE tab at dcbar.org.
Thanks, Scott.